Well, good morning. We are here on July 7th, 2026 at 10 a.m. for the commission meeting of the Alcohol and Tobacco Commission. My name is James Payne. I am the vice chair of the commission. The chairwoman, Jessica Allen, is in a much deserved and well-earned vacation, so I will be conducting as chairperson the meeting today. I at this time call to order and note that there is a quorum present. For those of you who are on remotely, we ask that you mute your devices. I have no clue to do that. I just learned recently how to do snooze button. So I am not technically advising you how to do that, but apparently we can do that if you cannot. It will be disruptive if you do not mute your device. This meeting, we will take no testimony or evidence today. This is just a meeting of the commission to rule on and report on certain things. The first order of business is the disposition of the minutes from June 16, 2026.
I have read the minutes of the meeting June 16, 2026 and believe them to be accurate. I move the acceptance of the minutes as proposed. Second.
Is there any discussion? Hearing no discussion then, all those in favor of accepting the minutes of the meeting of June 16, 2026, say aye.
Aye.
Aye. All opposed? We show the motion carries. The second item on the agenda is the prosecutor's recommendations, those that are known as the PAD form reports.
Members of the commission, the prosecutor has presented a report of the recent fines for alcohol and tobacco violations. That report reveals that there are 78 fines for a total of $58,000. Several of them are worthy of note. We have 15 permits that were owned by several LLCs that are all combined. Central Indiana Package LLC, Liquor Depot LLC, Sing Liquors LLC, and India Dining Group LLC. And in June of 2025, it was determined that several forged tax clearance letters were filed with the ATC in order to renew several permits. Violations were written in for falsification of records and reputation and character. In lieu of revocation of all of the permits, the parties have agreed to a total civil penalty in the amount of $19,000 for the permittee to pay tax liabilities to the Indiana Department of Revenue, to seek a transfer of the permit within 45 days, and for the ownership group to not seek any future ownership or managerial interest in an alcohol permit in the state of Indiana. We also have a permit held by DG Properties LLC, doing business as Pierre's, located in Fort Wayne, Allen County. Two recent issues at the business: in December 2025, a stabbing incident where the victim died inside the business. And in March 2026, a large party took place where numerous underage subjects were found consuming alcohol. The business was placed in a PACE program back in June of 2025 and is now closed. The parties have agreed to a $2,000 civil penalty and to place the permit in escrow for a sale to an independent party in a new location. Also, we have a permit owned by Two Star Inc. doing business as the New Yorker here in Indianapolis. In 2025, excise officers followed up on a shooting at the business that was investigated by the IMPD. It was determined the patron discharged a firearm inside the business. Violations were written for public nuisance and a sale to intoxicated persons. The parties have agreed to a $2,000 civil penalty and a 3-day weekend suspension. Finally, we have Yadagarasu Raman in Bloomington, Monroe County, and officers saw an 18-year-old with an alcoholic beverage who confirmed he was not asked for identification. The business has had several past issues with turning the restaurant into a nightclub and serving minors. The business was placed on PACE in May of 2026, and the parties have agreed to a $2,000 civil penalty and a 3-day suspension of the alcohol permit. I move the acceptance of the prosecutor's PAD reports. Second.
Is there any further discussion? Hearing no further discussion, The motion is made to accept the prosecutor's pad report. All in favor of say aye.
Aye.
All opposed say no. Motion carries. Next, hearing judge's recommendations. There are, I think, 8 of those today. I heard almost all of these, so I'll be reporting those. The first is TC 1689001, along with excise report 24-2003-448, having to do with OC Mart in South Bend, Indiana. This was an excise report indicating that there were violations discovered by the excise police. There was a notice sent by the prosecutor requesting a meeting to discuss the matter. They failed to appear, so it was set for a show cause hearing. The evidence revealed that a permit visit on September 25th, 2025, there was a complaint alleging drug activity. On inspection, the officer located several bottles of liquor. An employee was actively smoking a cigarette. They observed a small plastic bag with suspected cocaine and a small digital scale with powder substance on it, which was positive for both cocaine. The hearing judge heard the above information, and under IC 7.13-23-2, the commission may A1 fine or suspend or revoke the permit, or fine and suspend or revoke the permit certificate of a permittee for a violation. Having heard the testimony and evidence presented, it is the recommendation that the suspension of the license of TC 1689001 be indefinitely suspended, during which time the permittee shall not sell or dispense in any way any tobacco products. During that time, the officers would have the right to enter onto the premises for a purpose of inspection and may seize or confiscate any and all items of tobacco or other products. Based upon the report, it is the recommendation then that the permit issued to OC Mart under TC 1689001 hereby be indefinitely suspended and fined $1,000 subject to the approval of the commission. That is my motion.
Second.
Motion has been made and seconded. Is there further discussion? All those in favor of the motion, please say aye.
Aye.
Aye. All those opposed say no. Motion carries. The second is the permit of Geist Retail Inc., TC 1635901. This is for 2 excise violations, 25003448 and 25003775. Again, the prosecutor had sent notice to the permit holder to have a meeting to discuss the settlement offer and so forth. Those were failure to appear. A rule to show cause hearing was held. At that hearing, the exhibits were submitted. Exhibit 1 showed a permit visit by the officers on September 25th, 2025, where they observed a minor male purchase tobacco products, and the clerk did not ask for ID. In addition to that, did not have a no smoking sign posted. There was no tobacco sales certificate posted. There was the allowance for self-service of e-liquid, and there were minors on the premises. Exhibit 2 was offered and received in evidence. Again, a visit conducted on October 8th, 2025, just shortly after that first visit, which revealed a large quantity of smokable hemp, loose and pre-rolled marijuana joints, and large quantities of other illegal substances. No one appeared on this matter. The exhibits were submitted. The evidence was heard. Pursuant to 7.1323.2, the commission may A1 fine or suspend or revoke a permit or certificate, or 2 fine and suspend or revoke the permit or certificate of a permittee. Hearing judge, having heard this matter, recommends that the permit under TC 1635901 be indefinitely suspended, during which time the permittee shall not sell or dispense in any way any tobacco or related products. Also during this period of time, excise may at its discretion enter onto the premises for purpose of inspection and confiscate any and all tobacco products that may be there, subject to the laws of the state of Indiana. In addition, it's recommended that the permittee be fined $1,000 for each of these violations for a total of $2,000. It is therefore the recommendation that the permit issued to Geist Retail Inc. under TC 163590001 is hereby indefinitely suspended and that they are fined $2,000, subject to the approval of the commission. That is the motion.
Second.
Motion has been made and seconded. Is there any further discussion? All in favor of the motion, please say aye.
Aye.
Aye. All those opposed, say no. Motion carries. The third is permit of Canby Retail Inc., TC 164040001. Again, two excise violations, 25003-709 and 25001-860. Again, notice was sent by the prosecutor of hearings and notices of discussions of settlement off. There was a failure to appear. A rule of show cause hearing was scheduled and the hearing was held. Exhibit 1 was often received into evidence indicating that the officers conducted a visit to the premises on June 6, 2025 and saw an underage female enter the premises and leave. The store clerk said she had purchased hemp flour. The premise did not have a tobacco point of sale sign and there was no tobacco certificate displayed. The second, exhibit 2, was often received. Officers conducted on October 10th, 2025, a permit visit on a complaint of sale of vapes to minors. The inspection revealed the marijuana smokable hemp products on display. Violations were written for failure to display tobacco certificate, no point of sale sign, minor entering the premises, and failure to post retail notice of selling. Pursuant to IC 7.1323.2, the commission may A1, fine or suspend or revoke the permit of certificate, or 2, fine and suspend or revoke the permit of the certificate. The hearing judge, having heard this matter regarding permit TC 164041001, recommends that the permit be indefinitely suspended, during which time the permittee will not sell or dispense in any way tobacco or other related products. During that period of time, excise would have the right to enter onto the premises and to seize any or confiscate any and all items of tobacco or other products. In addition, pursuant to 7.1323.2A2, the permittee is fined $1,000 for each of those two violations. It is therefore recommended that the permit issued to Canby Retail Inc. under TC 164044001 and be indefinitely suspended, and that they be fined a total of $2,000. That is the motion.
Second.
Motion's been made and seconded. Is there further discussion? All those in favor of the motion, please say aye.
Aye.
Aye. All those opposed? Motion carries. The next is Post Retail Discount Inc., TC 168660001, excise number 25003-788. Prosecutor had sent notice of meetings to discuss the excise violation. There was no appearance and no one appeared. A hearing on rule show cause was set and disclosed on exhibit 1 that a permit visit on October 15, 2025 resulted in the officer purchasing marijuana. Was told it had to be sold out of the back room. There was a weighing scale with marijuana residue on it. There was no open system retail certificate on site. Violations were written for the reasons indicated. Under 7.13-23-2A1, the commission may fine or suspend or revoke the permit, or 2, fine and suspend or revoke the permit of certificate. The hearing judge, having heard the testimony under TC 165590001, moves and suggests that the permit be indefinitely suspended, during which time the permittee shall not sell or dispense in any way any tobacco products. During that period of time of suspension, excise officers are authorized to enter onto the premises for inspection purposes and to seize or confiscate any and all other items of tobacco products. In addition, pursuant to 7.1323(2)(a)(2), the permittee is recommended to be fined $1,000 for the violation. Therefore, the recommendation that the permit issued to Post Retail Discount Inc. under TC 168-66001 there are 3 zeros, be indefinitely suspended in order to pay a fine of $1,000, and that is the motion.
Second.
The motion's been made and seconded. Is there further discussion? All in favor of the motion, please say aye.
Aye.
Aye. All those opposed say no. The motion carries. The next one is the permit of Shri Yuma Nab Shakit LLC under TC 165590001, excise number 25003949. Again, the prosecutor sent notice to the permit holder to discuss and meet regarding the violation. There was no appearance and no one appeared. So the matter was set for a room show cause hearing. At that hearing, evidence under Exhibit 1 was often received into evidence indicating that excise had visited the location on October 22nd, 2025 and conducted a purchase of smokable hemp and found tobacco cigarettes for sale using a Kentucky tax stamp, not an Indiana tax stamp, and self-service displays of tobacco products. Based upon that, pursuant to 7.1323(2), the commission may A1, fine or suspend or revoke the permit, or 2, fine and suspend or revoke the permit certificate. The hearing judge, having heard this under TC 165590001, recommends that the permit be indefinitely suspended, during which time the permittee shall not sell or dispense any tobacco products, and during which time the excise police have the authority to enter onto the premises for the purpose of inspection and to confiscate or seize any and all tobacco products. In addition, based upon the violation of the testimony and evidence presented under IC 7.1323(2)(a)(2), permittee recommends to be fined $1,000 for the violation. The motion, therefore, is that the permit issued to Shri Yunvad Nav Shikit LLC under TC 1655901 be indefinitely suspended and that they be fined $1,000.
Second.
Motion's been made and seconded. Is all in favor of the motion, please say aye.
Aye.
Aye. All opposed, say no. The motion carried. The next one is the Cave LLC under TC 1773001, excise number 25003754. Prosecutor had sent notice to the permittee to discuss the matter of the violation that was filed. No one appeared and there was no appearance on file. The matter was ultimately set for a rule of show cause hearing on May 21st, 2026. Exhibit 1 was often received in evidence stating that the officer conducted a permit visit on November 18th, 2025 on the complaint of marijuana sales. The officer observed a plant material on display for sale that appeared to be marijuana. After observing the cabinets, he discovered an additional 114 items of smokable hemp or other marijuana products by sight or smell with price tags on them. All those were seized. Based upon Indiana Code 7.13-23-2, the commission may A, fine or suspend or revoke the permit, or 2, fine and suspend or revoke the permit. The hearing judge, having received the evidence under TC 1773001, requests that the permit be indefinitely suspended, during which time the permittee shall not sell or dispense in any way any tobacco products, and during which time excise may enter onto the premises for the purpose of inspection and seize or confiscate any items of tobacco products subject to the laws of the state of Indiana. Finally, under Indiana Code 7.1323(2)(a)(2), that the permit be fined $1,000 for this violation. The motion, therefore, is to indefinitely suspend the permit issued to the Cave LLC on the TC 17730001 be indefinitely suspended and that it be fined $1,000.
Second.
Motion's been made and seconded. All in favor of the motion, please say aye.
Aye.
All those opposed, say no. Motion carries. The last under this series of hearings, real or should cause hearing, regards again the Cave LLC, a TC 172540001 with two excise violations, 25003977 and excise 25004137. Again, the prosecutor sent notice to discuss the matter of the violation. No one appeared and no appearance was on file. A rule of cause hearing was heard. During that hearing, Exhibit 1 was often received in evidence, indicating that the officers conducted a permit visit on November 9th, 2025 to serve a suspension order when he observed what he believed to be smokable hemp in a vending machine on the sales floor in a glass vending machine. He also noticed the products had the odor of marijuana and seized those items to be smokable hemp. Exhibit 2 was often received evidence indicating the officers again went to the store on October 24th, 2025. On entering, he observed smokable hemp on display and saw a customer and smoking it. Thank you. Smokable hemp pre-rolls. All of the items of smokable hemp were seized. There were approximately 235 separate items that were seized that day. Pursuant to IC 7.1323.2, the commission may A2 fine or suspend or revoke the permit, or 2 fine and suspend or revoke the permit certificate. The hearing judge, having heard the testimony under TC 172540001, recommends that the permit be indefinitely suspended, during which time the permittee shall not sell or dispense in any way any tobacco product or related product. During that time, the excise will have the right to enter onto the premises for purpose of inspection and to seize and or confiscate any and all items of tobacco that may be for sale. In addition, under IC 7.1323.2A2, permittee may be fined $1,000 for each violation. Recommendation that the fine indicated be imposed. It is therefore recommended that the permit issued to the Cave LLC under TC 172540001 be indefinitely suspended and that they be fined $1,000 for each violation for a total of $2,000. That is the motion.
Second.
Motion has been made and seconded. Is there any discussion? All in favor of the motion, please say aye.
Aye.
Aye. All opposed? None. Will show the motion carried. That takes care of the tobacco show cause hearings. There were 3 other hearings held. The first involved CS Enterprises Inc., also known as CSA Entertainment Inc., under RR 45-38177, also CT 45-32485. This was a matter from Lake County. The Lake County Alcohol Board, a local board, recommended that the renewal of the license be suspended, be denied. Permittee filed a notice of appeal that was heard on March 26th, at which time the hearing judge made a finding in order regarding this. Specifically, the finding was that the permittee is in the name of Alicia Owens, who is the primary responsibility for conducting the business. Even though that is the case legally, she relied on her brother Winifred Owens to operate the business. She is employed full-time, working with dementia patients as a full-time nurse, and also cares for her 88-year-old mother. In other words, her activities personally kept her from operating the business, and her brother Winifred ran the business. They had some family money, as I recall, from the death of her husband, and invested in that in the restaurant. the brother Winifred convinced the parties, particularly the permittee holder, to expand it to a bar restaurant, which was conducted and being held. In addition, the brother then later decided that he wanted to open a cigar bar and was spending a great deal of time in Nicaragua, learning the tobacco business and arranging to open it. At that time, neither he nor the owner, Alicia Owen, were actually operating the facility. That was left to others to operate who had the keys. In other words, there was no management oversight, and the management staff, including the bartender, had difficulty running the place, and the witnesses testified that the staff were stealing things. While the permit expired on May of 2025, it remained open, even using social media to advertise that it was open for activity. So they are operating under an expired permit. Several times there were hearings that were missed because Winifred Owens, who was actually managing the operation, failed to appear. Alicia Owens was not actively involved, so was unaware of what was happening. Effectively, Alicia Owens conducted very little of the business of the permit and left the business in the hands of her brother, who she knows was traveling extensively to Nicaragua for other business activities. And in the meantime, even though the permit had expired in May of 2025, the business was open on operating and no removals were filed. Several violations occurred, and there was a large property tax debt of around $20,000 that was unpaid. The local board in Lake County, having heard the testimony evidence, denied the renewal. At the conclusion of my hearing on March 26, 2026, I instructed Alicia Owens, because she was very compelling in terms of wanting to continue to operate and to take control, to communicate with the ATC processor on steps that could be taken to bring the permit into compliance so that it could be considered even as an operating business. She was given 30 days to do that. While she tried to do a number of those things, she was not successful and did not complete all of those things, such as the property taxes. But there were other things that were not complied with. Therefore, based upon that, in fact, we received, I think this morning, a notice from Winifred. It was an email saying, can you let the commissioners know that I apologize for all the bad decisions I've made concerning CSA Enterprise, and it's all my fault. I beg of them not to take away Alicia Owens' license. The fact is that they have been operating illegally. They operated illegally for a period of time, and they failed to attend a number of hearings before the local board. The local board determined that they would not support continuing the license based upon the evidence and testimony and the records involved at ATC, the local board hearing, and the inability to comply with the suggestion that they bring everything current so it could be considered as open. I recommend that the local Lake County Local Board Alcohol Board denial of the renewal of the be sustained, and that the license not be renewed.
Second.
Motion's been made and seconded. Is there any further discussion? All in favor of the motion to support the Lake County Local Alcohol Board, say aye.
Aye.
Aye. And all opposed, say no. Motion carries. The second regarding alcohol permits is Playos Nightclub LLC, permit RR 4536364. Playos is a nightclub located in Gary, Indiana. The local board heard the issues regarding this. There were demonstrators who appeared several times. A hearing was held by the local Lake County Alcohol Board, and they denied the renewal. It came to the commission and its hearing shortly thereafter. The commission referred this back to the local board, Lake County Board, for them to consider the issues of who was the actual owner and operator of the business. The local board, Lake County Board, reheard the case and this time voted 4-0 to deny the renewal of the permit. This was heard as an appeal, a timely filed appeal, and the evidence disclosed that this business began operating in the year 2020. There were some issues that escalated over the next 2 years. In 2022, there was a shooting at the location, which resulted in 2 deaths and 4 injuries. As a result of that, the permittee was placed on a PACE program. That program through ATC for those with significant problems and issues to address was monitored very closely through the period of time. Along with that, the local county and particularly the city of Gary was looking at and reviewing the operation in great detail. And they agreed that they would lift, they had issued a closure for the facility. They lifted that closure and it began operating again. On July 2nd of 2025, the permittee Playos did not appear for the renewal hearing before the local board, and a number of remonstrators appeared. It was rescheduled, and eventually on September 3rd of 2025, Playos, the permit holder, appeared before the local board, as did a number of remonstrators with several members of the city of Gary through the mayor's office and the police department. At that hearing, the chief of staff for the city of Gary testified that the location has a troubled history of incidents endangering both patrons and the surrounding community. In addition, the deputy chief of the Gary Police Department testified that the location has a series of serious increases in patrols and in police manpower, including 12 incidences since 2022, some of which resulted in death, sexual assault, and firearms incidents. Indicated they have to extend patrols in the area when there are activities going on. They monitor the Facebook and social media of Playos about the entertainment and the potential for violence. In addition, the commander of the Gary Police Department indicated that he was personally responding to some of the calls at the location, and it puts a great strain on the Gary Police Department and their resources and funding. The attorneys for Playos at that hearing, the local board hearing, made an argument regarding the incidents of June 22nd and the agreement with the city thereafter. And that in 2025, there were 2 incidences that occurred, which they explained. Testimony was presented that Playos added security, some of whom work at the Indiana State Prison. At the end, a motion was made to renew the permit for 1 year, which motion was seconded and was voted for 2-1 renewal and 1 against. The matter was then referred to the commission, which then referred the matter back to Lake County with instructions to address the issue as indicated of the ownership. The second hearing was held by Lake County on December 3rd, 2025, with Playos appearing by Belinda Cooper as owner and Jerry Heeman as manager. Again, the commander of the investigations, the Gary Department, stated that while they agreed to change the entertainment, Playos have recently contracted for a concert with a known rapper that violence seems to follow. Based upon this and the questions that were presented on the ownership issue, Jerry Hammond testified that he was now identified as the manager and through a manager's questionnaire, where before he had variously been described as a marketing and booking agent, manager, resident agent, CEO, principal of the business, cook, and at times directly as the owner. Based upon all of these findings and the information. It's the recommendation that the findings of the local Lake County Alcohol Board are not arbitrary and capricious, or are they abuse of discretion. The facts support the denial of the renewal of the issuance of permit under RR 45-36364. It is my recommendation that this commission follow the recommendation of the Lake County Board, a local alcohol board, and deny the application renewal for RR 45-36364 Playos Nightclub LLC.
Second.
Motion's been made and seconded. All those in favor of the motion, please say aye.
Aye.
I,
Aye.
I just.
Sure, please.
That, the permittee, did have representation and they did, submit an objection to the proposed findings, facts and conclusion of law. And, we did, receive those and read those over. I think the primary point on there was they believed that that they completed PACE and, that there was not enough, attention paid to the corrective measures and their completion of PACE. I'll just note that there were some very violent acts and falsification of ownership, and I already voted in favor of the proposed findings, facts, and conclusion of law, but just want to point out that they did file objections to those.
Thank you. I forgot to mention that I did review that, and it seemed to me it was just asking again to reweigh the evidence already submitted. Thank you for pointing out. The motion's been made and seconded, and it's been voted on. The last one on the agenda is Fusion Inc. DBA Moon Bar and Grill under permit number RR 49-39978 here in Indianapolis. This was a hearing before the Marion County Local Alcohol Board for a type 210 beer wine liquor permit at 148 East Market Street. Local board had a hearing on October 6th and voted for it to deny the renewal by a split vote 3-1. This hearing was adopted by the commission at its hearing on October 21st, 2021. Having accepted the recommendation of the Marion County Local Board, a timely appeal was filed, and on March 19th, the hearing was conducted regarding that appeal. The evidence submitted was, there was testimony evidence presented, which included an extensive report from the permittee and included the review of the local board meeting and the records of the ATC initial was taken up. The information revealed that the permittee opened its business on July 2023. As a result of that, the continued to operate, and there was a notice of violation for employees permitting issues and settled by paying a $250 fine. In March of 2025, a new hotel opened adjacent to the premises, and there were a number of complaints and concerns about the noise and activities that were occurring on or about the premises of the permittee. On March 5th, 2025, excise inspected the premises, and the permittee was out of the country at that time. As a result of the inspection, there was another notice of violation filed, which was ultimately admitted, and a $1,000 fine was paid. The violation at that time in March of 2025 included not having server training certificates on file, not having employee permit issues, not having a manager on file with the ATC, smoking prohibited in public places, minimum food requirements, and public nuisance for discovery of marijuana on the location. After that, and as a result of the admission, permittee filed an extensive list of changes that they were making and identified many of those changes that were implemented, ultimately contained in what is known as a corrective action plan. The corrective action plan was extensive and promised a number of things. It included firing the company that was used for security, increasing the number of staff, working with IMPD to hire IMPD officers as off-duty security. Had two ODEs, off-duty officers working on Friday and Saturdays, monitoring the door. Other changes included how they would inspect people entering, no smoking devices, using a wand to search. In other words, extensive changes, including one of the issues that had presented itself in the past was there were security cameras there, but that they were in the open and available to be monitored or managed even by non-staff. And there was a move to change the location of those, the control of that to a more private and secure location. They even indicated they were changing the POUR size of the premises, 1.5 ounces to 1 ounce. In other words, there was an extensive and very appropriate, I think, CAP program, corrective action plan submitted. In the months that followed, there were changes made, also in its software to track employees and patrons. When they appeared before the local board, IMPD, the local police, remonstrated on consideration of the renewal. Additional representatives from the Downtown Indy Alliance and Christchurch Cathedral demonstrated. Argument was heard regarding the reasons for the remonstrance, and there was extensive testimony presented on issues like parking, theft in cars that were in the area. Having heard all of that, the local board voted 3-1 to deny the renewal. And following that appeal hearing, the hearing was held regarding the local board denial and what occurred. Testimony was extensive testimony presented, extensive evidence was presented regarding the incidences, the conduct and behavior, and what occurred. At the end of the hearing that was heard in this room, the permittee asked for permission to submit a sworn affidavit on commitments that he would make regarding any changes to the operation if the hearing judge and the commission would not sustain the Marion County Local Board. They included changing the new concept from a bar hip hop music to a sports bar, similar to others downtown. That they would open weekends from 10 a.m. to 11 p.m. and weekdays from 11 a.m. to 2 a.m. Next, that they would add a retro arcade games to the second floor. That they would feature salsa lists. That they would be more food focused than the current business model. And that it would be classified, it was unstated how, under the Indianapolis zoning ordinance as a bar or tavern, and not as currently as a nightclub or cabaret. Finally, they committed that the violations for high and fine reputation could be used in the event that they were allowed to stay open and to change the operation. Frankly, that was a compelling argument. The appeal of the local Marion County Board was based upon the evidence presented to the board at that time. The hearing on appeal in this room before the commission that I served as hearing judge was a de novo hearing, which means in Latin, a do-over, do it again. And additional evidence was submitted. Even after that hearing, though, an affidavit was filed approximately 30 days later with those changes that I indicated would be made, changing it from a hip hop bar to a sports bar, the hours and so forth, a promise to make those changes. I found that interesting, but I was also frustrated that the local board was not able to hear that and consider that. The standards on appeal of a denial of a local board are to look at the rulings made by the local board based upon whether or not they were arbitrary and capricious, contrary to the constitutional rights, in excess of or contrary to statutory jurisdiction, or without observance of procedures required by law or supported by substantial evidence. The local Marion County Board hearing that they heard was not arbitrary and capricious. It was not contrary to constitutional right. It was not in excess of or contrary to the statutory jurisdiction. It was not without observance of procedures they did, and it was supported by substantial evidence. I was concerned, frustrated that at the last minute, at the last hour, that the local board did not have the chance, and the permittee did not see a reason to submit to the local board the proposed significant changes. I go through all of that because this, I think, is a unique situation. The process was in some ways subverted because the local board did not have the opportunity to hear all the testimony that was later presented, not only during the hearing, but even after the hearing by an affidavit. And I say that because my recommendation is that this commission, support the denial of the local board to renew the permit of Fusion. But I gave in the order the right of an authority to remand this back to the local board only for the purpose of considering the affidavit that was submitted. That affidavit is attached to the proposed order. It is an affidavit of Tajender Singh, setting out many of the things that I've already described and a few more. I did not describe everything. I find it untenable for the local board to not be given the authority to hear things. We rely very closely on what happens at the local board. They are most associated with the community, with the neighborhood, and with the business, and they should have the right to have presented to them all of the information as they make a decision. That did not happen in this case. I'm recommending, therefore, that this commission support the local Marion County Board in their denial of their renewal. But I'm also recommending that if the Fusion permit holder chooses that this be remanded to the local Marion County Board only for the purposes of reviewing the affidavit that is attached to this document, not for further testimony, not for evidence. The local board heard this case. They made their report recommendation based upon the evidence that they had, but new evidence has been presented. If they find that compelling and the local board chooses to change their recommendation, they can do that and make that known to us. If they review that on the request of the permit holder and choose not to make a change in their recommendation, then the commission's order sustaining the finding of the Marion County Local Board stands and the renewal is. That is my motion. I am available to answer any questions.
Second. I just had a question.
Can I say something?
Sure.
Is there any further discussion?
Yes, I applaud you. I thought this was a very good proposed finding facts and conclusion of law. I do also agree that there has been substantial new information that has come to light from the permittee that may be considered differently in the local board recommendation to us. I think it is appropriate in this case, not all cases, but this case, to refer this back to the local board, see, after they review the affidavit, and any other questions they have, that possibly they have a different, recommendation to us. I just want to acknowledge that the location where this business is located has changed a bit with the hotel coming in and with condos or whatever being built above the permittee current location. And I like that possibly they're going to consider changing from a more nightclub bar to more of a restaurant focused facility. I think that personally, I think that makes a lot of sense for where this business is currently located. Not that they couldn't take their permit and go elsewhere if they wanted to. But I support their recommendation, and I have one question. Is there a time period on when they need to request this to go back to the local board, or is it automatically going back to the local board?
Thank you for mentioning that. I think, as I recall, and I didn't mention this, the permittee was given a limited period of time to decide whether or not to request a remand for the local board to consider the affidavit only. And if I didn't, I meant to put in there 15 days, that he would have, the permittee would have 15 days on doing this. I don't know if that's in here. I'd have to study again, but that was my intent, that the
Okay.
limited period of time.
So
If that's-
15 days from today,
Yes,
after we rule on this, then they have to, if they would like, to request the remand to the local board.
just to,
We're allowing it,
Yes.
and they can say, yes, we would like that
yes.
within the next 15 days.
Thank you for pointing that out.
Thank you.
Any further discussion? All in favor of the motion, please say aye.
Aye.
All those opposed say no. The motion carries. Next order of business are the consideration of the applications. The first 491 renewal applications.
I incorporate by reference this list of 491 applications for renewal, which have been recommended by local boards and reviewed by our staff with authority of the commission. And I hereby move for approval of same pending any needed escrow hearings and inclusion of this list in the minutes of this meeting on July 7th, 2026.
Second.
All in favor of the motion, please say aye.
Aye.
Aye. All opposed? Motion carries. Next is 26 new and transfer applications.
I incorporate by reference this list of 26 permit applications for a new permit or application for changes in ownership or location or both of existing permits, which have been recommended by local boards and reviewed by a commissioner. And I hereby move approval of the same pending a floor plan approval by the Indiana State Excise Police and an escrow hearing if needed, and inclusion of this list as part of the minutes of this meeting of July 7th, 2026.
Second.
Been motion made and seconded regarding the 26 new and transfer applications. All in favor of the motion, say aye.
Aye.
Aye. All those opposed? Motion carried. Next, 76 catering applications.
I incorporate by reference this list of 76 permit applications for catering, and I hereby move for approval of same and inclusion of this list as part of the minutes of this meeting of July 7th, 2026.
Second.
Motion been made and seconded regarding the 76 catering applications. All in favor of the motion, say aye.
Aye.
Aye. All those opposed? Motion carries. Finally, 54 direct wine shipper applications.
I incorporate by reference this list of 54 new and renewal direct wine shippers application permits, and I hereby move approval of same and inclusion of this list as part of the minutes of this meeting of July 7th, 2026.
Second.
Motion's been made and seconded regarding 54 direct wine shipper applications. All in favor of the motion, say aye.
Aye.
Aye. All those opposed? Motion carries. The next item are waivers of fees for letters of extension.
Members of the commission, I move acceptance of the waivers of fees for letters of extension issued since our last meeting.
Second.
Motion has been made and seconded regarding the waivers of fees for letters of extension. All in favor of motion, say aye.
Aye.
Aye. All those opposed? Motion carries. The next are items for discussion. To begin the meeting, I want to point out that we have 4 additional items to add to that. I would ask for consent regarding RR 49-04389 RCA Dining Services Inc. DL 49-32035 Raja Oil Inc. RR 10-39593 Fireside LLC. And finally, RR 64-29637 Linker License RS Cap P10 LLC. Can we have those by consent?
Consent.
Consent. Okay. The first then is RR 49-43795 Outside Noma LLC. A request for catering hall conversion.
Yes, this comes to us from Marion County. Our deputy commissioner has had conversations with them, has submitted the proper paperwork. They are converting from a 210 permit to this catering hall, which means they must have seating for at least 250, and that has been verified, and they do understand that they are holding private only events unless they get approval from the commission for a public event. And that is for RR 49-43795 Outside Noma LLC. I move that we convert this permit to a full catering hall permit.
Second.
Motion has been made and seconded. All in favor of the motion, say aye.
Aye.
Aye. All those opposed? Motion carries. I'll assume there's no discussion, but I'll remember to ask that from now on. The next one is RR 5536111 Gillespie Cigar Bar Inc. Motion to reinstate.
Yes, this was made dead, and there is a motion before us to reconsider making this back to an active status. On 3/3 of this year, we did post that it was going to be made dead in a non-auction status. On 3/17, we did make it dead in a non-auction status. The permit has been expired since August of 25. They do not have insurance. They have not provided to us. It was closed in January. They stated that their insurance required the insurance agent to do audits of their account. That agent who had been doing the audits retired and did not complete the insurance agency audit. They asked about it, and they were advised that they were getting a new agent, but still the audits were not done and the insurance lapsed. They have been having problems getting an insurance since they were in a lapsed insurance status with another company. I will note that they have 2 renewals that are required with us. Those have not been filed nor paid for. We did receive a letter from their counsel that was dated June the 12th, asking for this relief. And I am going to move that we do allow this to be placed back into active status if we receive the 2 years of renewals fully, any paperwork required, and the payment of the fees for those 2 years. And I do want that to come in within the next 10 days on July the 17th of 2026. And if those renewals are here fully with payment, then the permit can be placed back into active status. If not, then the permit remains as is, as a dead permit. Now, that's my motion.
Second.
So point of order, I've just noticed on my records that the motion to reconsider reinstate filed by the permittee lists two.
One is the permit and one's an underlying permit.
So we're okay.
Yes, we're okay with both of those
Okay.
permits. The one ending 111 is a beer permit, and then there's an underlying 112, which is the beer wine liquor conversion permit.
So we don't have to worry about that 1112.
We,
Okay.
my motion is that
Okay.
we allow both of those permits,
Okay.
RR 5536111 and RR 5536112, to be
Okay.
made active if they receive the renewal and the payment, all paperwork before July 17, 2026.
Okay, the motion has been made and seconded regarding RR 55-36111 and 36112. All in favor of the motion, please say aye. Aye. All those opposed, say no. That motion carries. Next is RR 45-38937, RR 45-38939, 38939, and RR 45-38936, Sauce Holdings LLC.
These come to us from Lake County and they were made dead. It's up for a reinstatement. I will note that due to a technicality with our internal system, on a second year expired permit, they did not receive proper notice that the permit was going to be made dead. The second year of expiration, just the first year of expiration. Due to the technicality, I'm going to make a motion that we reinstate all three permits noted for self-holding LLC. Second.
Motion has been made and seconded. All in favor of the motions, please say aye.
Aye.
Aye. All those opposed, motion carries. Next is RR 45-06950, Susco Corporation request to renew and file transfer.
Yes, this was a vote of local board 4-0 to deny. They had violations dealing with public nuisance, falsification of records. The permit was made dead. I will note that we did state in the order to them that we would allow for a transfer only. It has to not include the existing location, cannot include the three current owners, has to be arm's length. I will note that whoever is purchasing this permit still has to go through the local board process to obtain their permit. Local board will vet that new owner and any new location and make a recommendation to us for final consideration. And I'm going to move that we do allow this request to renew and file for transfer. And of course, that is just for transfer only. We are not allowing this permit to be resurrected for the current owners. And that is for RR 45-06950 Susco Corporation. That's my motion.
Second.
Motion has been made and seconded. Is there further discussion? All in favor of the motion, please say aye.
Aye.
All opposed, say no. Motion carries. Next is DL 29-34270, Indie Liquors LLC, request for remand.
Yes, this involved two owners and one's a ex-husband, ex-wife. The ex-husband had problems with a different permit that he owned with somebody else and violations on that, and which caused problems with his ownership on the Indie liquor permit. They have now filed paperwork, and the ex-wife owns this. The ex-husband is no longer an owner, no longer associated in any way with this Indiana liquor permit. And they are requesting a remand back to the local board to allow this permit to be renewed in just the ex-wife's name only. And I'm going to make my motion that we do allow a remand to Hamilton County for consideration of the renewal of this permit in the ex-wife's name only for DL 2934270 Indie Liquors LLC.
Second.
Motion been made and seconded. I would just comment that, as you indicated, there are extensive documents presented. I was particularly interested in the document that indicated the parties went to the local police department to make sure there is a no trespass order. In other words, the ex-husband is not allowed to attend or be at the premise at any time. Therefore, I think further supporting the separation and the fact that he will not be involved. I thought that was a good touch. All in favor of the motion, please say aye. Aye. Those opposed don't, say no. Motion carries. Next is R 39-40100 Rivertown Eatery Inc. requesting additional escrow hearing.
Yes, this permittee has had two previous escrow hearings. Those were on April the 28th, May the 27th. Because they didn't show up for escrow, they were denied. The permit came before us on June the 16th. And we did make the permit inactive. They have now hired counsel. Counsel has filed a request for us to allow this to be heard one more time as escrow. I would have liked maybe a little bit more in detail about why it needed to be remanded, or not remanded, but considered for escrow again. Instead of just all the statutory reasons, what happened with the permittee, that they did not appear for those events. But regardless, I'm going to recommend that we send this back for one additional escrow hearing only. That will be on July the 28th of this year, of this month. One additional time to appear and renew escrow. And that is for RR 39-40100 Rivertown Eatery Inc. Second.
Motion been made and seconded. The comment I would suggest is that I don't understand the business model where you pay for and request and go out of way to ask for a permit, knowing that it has to be renewed or certain steps need to be taken administratively, and then failing to show up. And I would just caution permittees that they run the risk that this is discretionary on our part. And I don't know that we'll continue to be as forgiving and understanding. They run the risk that we will not allow another hearing and they will lose the permit. I just wanted, for those listening, communicate to others that these hearings take a great deal of time and effort by the local boards, by others to schedule and reschedule. Let's attend these hearings, folks. That hasn't been said. Motion's been made to approve the additional escrow hearing on July 28th. All those in favor of the motion say aye.
Aye.
Aye. All those opposed? Motion carries. The next is DL 49-13408 Cox Enterprises Inc. A hearing to convert jurisdiction from Indianapolis to Cumberland.
Yes, House Bill 1131 passed in 2025 and created a separate city for Cumberland, Indiana. This permit was issued for a packaged liquor store in Indianapolis, and now it's located in the boundaries of Cumberland. I think it is correct to convert this to the correct jurisdiction, which is now Cumberland. They did file Form 44184. County surveyor has signed it that it is in Cumberland. And I move that we convert this jurisdiction from Indianapolis to Cumberland for DL 49-13408 Cox Enterprises Inc. Second.
Motion has been made and seconded. Is there any further discussion? Hearing none. All in favor of the motion, please say aye.
Aye.
Aye. All opposed, say no. Motion carries. The next is MM 48-30635 Cultured Urban Winery LLC, an extension request.
Yes, this permittee has had 4 extensions. They've been expired for over a year. They need a current renewal. It is not on file. They have a property tax issue, which is keeping them from renewing. I will note that they have hired an attorney and they have met with the county assessor. That was on April the 17th. They did propose to the assessor a settlement amount that they would be willing to pay. And as they state to us, they have not received any information back from the assessor if they're going to accept that or come back with a different amount or work it out some other way. During the meantime, they need a 5th extension in order to remain active. I don't remember issuing 5th extensions. There are not very many. This is unusual. I am going to recommend that we do, I will note that they do not have any violations, which that weighs highly with me. You don't have any violations on your business. And hopefully that'll remain the case. Otherwise, we may pull the extension. But I'm going to move that we recommend that I move for this 5th extension. But if they need to come back for a further extension, I think we're going to need further information from the county assessor as to what's going on when this may be settled. Also note that they do need a current renewal. It is not on file. They have a current extension which expires July the 20th. So get the renewals in right away on this. And I'm gonna make that motion for the 5th extension, 90 days. For MM 4830635 Cultured Urban Winery LLC. In the renewal needs to also come in before the expiration of the current expiration extension, which is July 20th. Second.
Motion's been made and seconded for discussion. I will only comment, I intend to vote no. I think 3 is enough, 4 is extensive, 5 is not acceptable to me. If the issue is the property taxes, pay the property tax, then appeal it. They can submit an appeal, I think. But I don't understand why it takes over a year to resolve problems, coupled by the fact that they haven't even filed a renewal. Seems to me they're just playing the system, and I don't like that. So I intend to vote no. But the motion's been made and seconded. All in favor, say aye.
Aye.
All opposed, say no. No. The motion carries 2-1. Yes. Further. Okay. Next is RR 84-42176. Servicios Dominguez LLC, an extension request.
Some source from Terre Haute. They also have property tax that is incomplete. They expired April the 1st. They do not have any violations. They have one extension from April the 2nd to June the 30th. I move that we grant a 90-day extension for RR 84-42176 Servicios Dominguez LLC.
Second.
Motion has been made and seconded. Is there further discussion? All those in favor of the motion indicate by saying aye.
Aye.
Aye. All opposed? They show none. The motion carries. We now go to those that have been added by consent. The first is RCI Dining Services, RR 49-04389.
Yes, this comes to us from here in Marion County. They have had violations, which have been settled. They were scheduled for the local board, on yesterday. And the Indianapolis Police Department did show up to remonstrate and ask that this be continued to August the 3rd. They have had, extensions. They expired April the 18th of this year. They had an extension from April 21st to May 19th and another from May 19th to July the 20th. I will note that their violations in the past, that there was a person shot and struck by a vehicle in the parking lot area. There was some issues obtaining video. I think we did receive the full video eventually. For issues with people entering the business that did not get carded, that appeared to have given money to enter without having been properly carded. I'm gonna move that we grant the extension until they have a local board hearing on August the 4th, and I'm gonna move that we grant this extension until our next, not the next day meeting, but 2 weeks after that,
August 18th.
so that we can look at the recommendation from the Marion County Local Board, and that would be an extension until August the 18th. That's my motion.
Second.
Motion's been made and seconded. Is there further discussion? All in favor of the motion regarding RCI Dining Services, Inc., indicate by saying aye.
Aye.
Aye. Those opposed say no. Motion carries. Next, added by consent was DL 49320335 Raja Oil, Inc.
Yeah, this permittee has had problems appearing for their local board meeting. They were supposed to be at their local board on May the 4th, June the 1st, and July the 7th. And they, that was July the 6th, sorry, and did not appear for those. They had violations too for falsification of records and for disclosures of information. I'm hoping that they will appear at the next local board meeting. And I'm going to move that we grant a 90-day extension for them to get through the local board and the recommendation to come back to us for DL 49322035 Russia Oil, Inc.
Second.
Motion's been made and seconded. Mine will comment, I will vote against the next, if there is a request. We need these permittees to understand their responsibility, just like we understand ours. All those in favor of the motion would say aye.
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 Aye. Opposed say no. Motion carries. The next is RR 1039593 Fireside LLC.
This permit is from Clark County. They have also missed 3 local board meetings. I will note that they are now represented by a preparer, and the preparer is taking a more hands-on approach to make sure that they can get to the next local board meeting. I will note that the preparer has stated to us that this individual has a medical condition that has probably caused confusion on their part. So I like that they're getting some hands-on help. I'm gonna, I think the next local board hearing will be August the 6th. I'm gonna move that we grant a 90-day extension. So really hope they can meet this next local board meeting. I'm not sure there'll be any more chances after that. 90-day extension for RR 1039593 Fireside LLC.
Yeah.
Motion's been made and seconded. I agree with your statement. All those in favor of the motion say aye.
Aye.
Those opposed say no. Motion carries. And the last of the consented add-ons is RR 643293637 liquor license RS cap E10 LLC.
Yes, this permittee has now completed all of the paperwork with us to renew their permit. They did expire April the 3rd. They did have an extension from April the 8th to July the 8th. They are scheduled for the local board on July the 9th. They have had a few violations for serving after hours, for gaming violations, and for serving minors. We have received a corrective action plan on this permittee. They'll be paying attention to our laws and regs more closely, be a good operator. I'm going to move that we grant a 90-day extension for RR 6429637 liquor license RS E10 LLC. Second.
Motion has been made and seconded. Is there further discussion? All in favor of the motion, then indicate by saying aye.
Aye.
Aye. All those opposed, say no. Motion carries. That concludes item 7 on our agenda. We do have inactive files. There are 6 permits to be made inactive from June 16, 2026. We have removed 2. Is there a motion?
Yes, I incorporate by reference these list of permit applications to be made dead today and hereby move for approval of the same inclusion of this list as part of the minutes of today's meeting.
Second.
Motion's been made and seconded. All in favor of the motion regarding those 6 permits, say aye.
Aye.
Aye. Motion carries. Just as a note, there are 19 permits listed and published to be made inactive on July 21st, 2026. For those who are concerned and interested, you might look at that and make sure that you research those. I show there is no old business. There is some new business permits for reconsideration, permits to be reconsidered on August 4th, 2026.
As reported at our last meeting, Chairwoman Allen stated that there is a list of permits that have been posted that were conditionally approved by the commission, some as far back as 3 years ago. They have not filed missing items such as Form 1s. They may have tax holds, etc., that are preventing these permits from being fully issued. Notices have been sent multiple times regarding the issues. These approval of these permits will be reconsidered at our August 4th, 2026 meeting. If the missing items have not been taken care of and submitted by that time, those permits will be made dead. Notice is here given on those permits.
Please take notice of all of that. We have, I think, one more item. Mr. Surak, do you have something to present regarding?
Yes, I have new legislation updates, so thank you for that. So we had a really busy legislative session, as I think everybody is well aware right now. Numerous changes, operational changes for Alcohol Tobacco Commission, including new wholesale tobacco sales certificates and a modernized e-liquid manufacturing permit. This obviously has wide-ranging impact on the industry. Alcohol permits were less impacted, but we do have a few changes that we've adopted that were adopted with an effect on ATC operations. All of these changes, tobacco and alcohol, are outlined in great detail in 2 webinars that our legal team hosted, which are available on our website, ATC's website, under legal and policy resources. All of the legislative changes have now been incorporated into permit and certificate applications, both online and on existing paper forms. New permits, just as an FYI, are not going to be made on paper. They're only going to be electronic. So if there's a new permit created, like the wholesale tobacco sales certificate, it's just going to be an electronic application. We're trying to phase out paper slowly but surely, and one way to accomplish this is by not creating new paper applications. That being said, we have updated all of the existing paper applications. So there are new versions, updated versions of the new and transfer forms and the renewal forms for retailers and dealers on the alcohol side. And those are on the ATC website as of July 1. And as usual, we'll continue to accept the old forms until around August 1st, 2026. At that time, those applications that are not using the new form will be returned. And as always, apply online is the best way because you can ensure that you got the most up-to-date form. Apply online. For permittees that are wishing to take advantage of the limited separation exception for minors under IC 7.15711A34, the affidavit to request this is online under the actions tool next to your permit. After a permit is linked using the registration code, 3 dots will appear next to the permit. This is known as the action menu. In the action menu, there's an affidavit called limited separation removal affidavit. This conversion requires that the permittee have sold at least $100,000 in food and non-alcoholic beverages in the prior year, not have type 2 gaming, and not allow smoking. We expect all permittees to make this conversion in a responsible manner that recognizes alcohol as an age-restricted product. After a request for removal of limited separation is made, the update will be forwarded to the local board officer and a final inspection will be scheduled. There's a full process that I sent out to the listserv. So if you're on the newsletter listserv, you should have gotten a full update on that process. It will be incumbent on the permit holder to make contact with the local board officer once the processor sends the completed and processed request over to the permit holder and the local board officer. So again, that information is detailed in that email. If you have questions, email me and I'll send you that summation of the process. As for tobacco, the new tobacco wholesaler and the updated tobacco retailer, and updated e-liquid manufacturing permit applications are all now online in My License One. And as one final reminder on the e-liquid front, e-liquid products that are fully manufactured or include component parts manufactured in a foreign adversary country that are not pending FDA approval or that obtained FDA approval are illegal to sell in Indiana as of July 1. So if those products have not been removed from shelves already, they should be removed now. So again, that's just another friendly reminder to all of our tobacco sales certificate and wholesale certificate holders. If you have foreign adversary products in your shelves, in your inventories, get rid of them in a legal manner. That's all I got. Thank you guys.
Holy cow.
Yeah.
For those listening and those involved, you've just heard a 5-minute discussion of what has been months and months of hundreds of hours of work. In 5 minutes, you condense that, but they are important changes, Chris, and you have done great service in fostering through and putting together all of this information. It's just astounding, but they are significant changes in here.
Yes, sir.
And people need to be aware of it. And many of these are posted online. You've done that and you're available for those who are listening and are interested. Follow up on this because these are important changes.
Absolutely. Yeah, no, the webinars are good resources. There's also PowerPoints associated with webinars. Take a look at those. Hopefully those will answer your questions. If you have process questions, the emails that we've sent out to our listservs should answer those. To the extent they don't, send us an email and we'll get back to you in the order received. Obviously, we have a high volume of requests in our inboxes right now. So thank you, Vice Chair.
But we owe you congratulations. Great. Thanks for all
Thanks,
that you've done.
Yeah, and the team really, Jeff Coyle deserves a lot of credit for the work he's done. Melissa and Daphne, everybody deserves a lot of credit for the work they've done. So
Yeah,
appreciate it.
We've just spent an hour and a half going through things that have taken hundreds of hours by team and staff and committees and groups, and we're so thankful for the staff for doing this.
Absolutely.
Excise.
Excise, yeah, everybody's just
Big
wonderful.
effort.
Is there anything further, Chris?
No, thank you, sir. Thank you, Vice Chair.
I show that's the last part of the agenda. The only thing I'll note is that on the amended meeting dates, Wednesday, November 4th is going to be a meeting in November. Usually it's on Tuesday. But for those of you who attend, those of you who are interested, even for those of you who are homeless, note the date, November 4th on Wednesday is a meeting. We'll entertain a motion at this time to adjourn.
So moved. Second.
All those in favor of the motion say aye.
Aye.
Those opposed? Even opposed. All right, we're adjourned. Thank you.